26th Judicial Circuit Court Judge Michael Mack was presented with multiple motions for summary disposition last Friday when a hearing took place between the Alpena City and Township. Judge Mack scheduled both parties to an all-day meeting at the end of the month and hopes to find a middle ground and avoid trial. Here's the latest. Alpena City is currently suing Alpena Township for partial non-payment of water and sewer bills. Attorney William Fahey is representing the township in this case, and their position states rates are not a lawful price and that the city is now charging the township a retail rate versus the wholesale rate they've been charged for the last 40 years or so. The township saw a jump in rates when the city hiked up the prices a couple of years ago, totaling to about a 65% increase, and City Attorney Jim Young says the township isn't special and is considered a retail customer. On July 15th, both parties entered motions to 26th Judicial Circuit Court Judge Michael Mack in hopes to have him rule on them at the end of August and avoid trial. The city brought two motions to the judge's bench: applications to federal rules with the Environmental Protection Agency and the case that certain statutes don't apply to them due to size. On the other side, the township requested summary disposition based upon the history of the dealings between the parties and the nature of the service the township receives, which they believe should be wholesale services, not retail, on the grounds that the township doesn't receive all the services that city residents do. But whether the township is a wholesale customer or not isn't the only thing the city and township disagree on. A big question is whether the 1977 contract is still active or not. The township says yes.
The reason for that is that there was a provision put in the contract back in 1977 that said that even though the period of the contract was for 40 years, that the township could continue the contract if it does not have an alternative supply of water and sewer treatment. And at this time, the township does not have an alternative supply of water and sewer treatment, and so we're taking the position that the contract is still in effect.
It is the city's position that the 1977 contract is no longer in effect because the contract said it would continue unless the township has a feasible alternative for water or sewer services. And a number of years ago, over a decade ago, the township had its own study done that found that the township could have its own system. And we had that study evaluated under current rates and costs. And again, while nobody wants that to happen, it is they do have a feasible alternative. And so as a matter of law, we just want the judge to rule that the 77 contract is no longer in effect.
Young says the city also claims the township is approximately $1.5 million past due.
So really right now that's just a number on paper. That's what the city says is due. The township has never agreed that that's an amount that's due. In fact, in this lawsuit, the township believes that the city owes the township about $2 million.
But if there is one thing both the city and the township agree on, it's avoiding trial.
It is my hope that we don't take the tremendous amount of effort that is necessary to have different experts do their analysis and have a trial that could take weeks and then have a party that's not happy appeal to the Court of Appeals or the Michigan Supreme Court. It is best if both sides try and find a common ground.
During the hearing, everyone was cordial and responsible. Judge Michael Mack says all these requests are under advisement. He's ordered both parties to plan to meet August 22nd and negotiate in hopes of finding an agreed settlement. In Alpena, for WBKB News, I'm Bethany Ricciardi.